So Nikitas is going to give us some of his insight from a international private law perspective.
So
on what I just what I just presented.
After, it's a great pleasure to be here with you. This is a very interesting topic, and probably we could spend an entire day just discussing Chris's topic. And now Eleni has brought us into something even more perplexing or complicated or high stake for Cyprus. So this means that I'm literally standing in the, well, after two very insightful presentations by experts, I'm standing in your way between another insightful intervention by Pantelis and the discussion that will surely follow. So I'll try to keep it brief, but I wanted to say how excited I am and intrigued by all this. And indeed, it appears that private international law is more relevant than even I would have thought. I'm not going to go into the doctrinal detail. Have other people who are much more proficient for that. But I'd like for a few minutes as a kind of interlude to the next stage, think more broadly, theoretical terms. You see, I assure you I only have 4 slides, essentially 2 main ones. Let's think about governance in terms of governance, EU governance or global governance. Assuming there is a real problem, which means that there is an unequal playing field, there is a lot of state capitalism. The EU was built on a model of ordoliberalism. We have changed a bit, but when the EU was constructed, we're dealing with a model of state capitalism, Chinese way. At the same time, we're also dealing with imperialism of multinational corporations. So there are problems that need to be dealt with. And so the question is, how do you deal with them? The traditional way, or the way that the international lawyer would have wanted, is multilateral. Ideally, by having an international institution determining who is violating the playing field, you set up international global standards, and then, for example, by GATS, on investment agreement or MIGA, and then you actually and then you have a body that adjudicates disputes. So WTO is the example, but WTO apparently is not working. It started very ambitiously in the 90s, taking over from GATT, but it's not that WTO is not effective. The Americans have thought it was going too far in some ways and not far enough in some other ways. We got especially we got the appellate body, and WTO being a unanimous, but WTO is right now neither a very effective lawmaker, not a very effective appellate judge, let's say. The other way, the classical international law way, would have been the horizontal one. You allocate jurisdiction between states. We know that state A will take care of a few things and state A will take care of other things. This is what you know as private international law, ιδιωτικό διεθνές δίκαιο, or conflict of laws, because private international law is also the other part, the unilateral extraterritorial. And in the conflict of laws, we think in terms of connecting factors, etc. This has even carried over to traditional tax law, even though tax law is also different. The bilateral approach is halfway between these two poles I'm presenting in this slide. You have indeed mechanisms for screening in bilateral investment treaties. You can have agreements in which the two countries or two regional blocks or one regional block and one country determine what goes. The problem, the bilateral approach in some ways it's the most efficient one. In some other ways it has a big problem. First, there tends to be an unequal power between the two sides. And second, in the case of the EU, you could have one foreign country or powerful foreign country essentially playing one of the member states against the other. And then you have, but this is an approach. This is an approach pursued by policymakers. at the level of EU, not the level of Cyprus, China, but the level of EU, China. And then we go to unilateralism. And unilateralism is both a weapon to actually get your counterparties to agree to a multilateral or a bilateral approach, and also a way to achieve your objective in the short term. And when we speak of unilateralism in this stuff, of course, America comes first. The United States is, in terms of doctrine, the mother of a regulatory unilateralism. I will spare you the why in terms of legal doctrine, but essentially, regulatory law tends to be applied unilaterally. Even the Cyprus Competition Commission is going to determine essentially what cases fall under its jurisdiction, and then it will apply its own law. But once we go broader, jurisdiction tends to be founded not just on a territorial criterion, which company operates in our territory, but on effects. And again, the Americans have written the book on that, and it expands, but the EU is also following that. We can see in terms of the data protection regimes. So the effects doctrine means that anything that impacts or has considerable effects in the forum, in our territory, interests us. And this means that you can have essentially that the forum can claim to have stakes in transactions taking place abroad. I'll come to this again in a moment. So this unilateralism can take 2+1 forms. The one is preemptive, the permission. If you want to operate, you have to take our permission. The other one is remedial, invalidate. Your agreement violates of public or violates our legislation, so we can come ex post and invalidate your agreement. The problem with the latter is that it creates even bigger prejudice sometimes. So the tendency, the expansion of unilateral regulatory regimes has gone hand in hand with the idea of permission or screening. And then what I mentioned as consensual is this idea that instead of just imposing something, we'll try to get you to conform. And again, the Americans have been the masters in that. There are, after having certain triggers that trigger US regulatory jurisdiction, the US will bring you in, and then you make an agreement with the US, which essentially you undertake to take certain measures. So essentially, this is a voluntary compliance. A company getting into this, who has to decide as to whether to fight the regulatory jurisdiction, or whether to, which it might win, might not win, but it will have sanctions and immediate consequence in the US, or whether to just agree to conform to the US standards, even if it's domestic regulatory might not like it. One case, for example, it's not, is Siemens. How the Americans essentially managed to control or subject to control everything Siemens will be doing all over the world. We know from Greece, but essentially everywhere. And this is part of asserting jurisdiction unilaterally on the basis that Siemens was also listed in the New York Stock Exchange, and also in terms of, well, you agree to that. Siemens agreed to that. So extraterritoriality can take, as I said, several forms. I can just decide I want to regulate the contact abroad of my own companies. And then the contact abroad of companies that want to come to my territory. This goes a bit further. Ideally, we could draw a line, continuum, as to what is closer and what goes further and what's really excessive. Then we go into not just looking as to whether your own business, and this is where the subsidies white paper goes much further than the FDIS regulation, in the sense that not just the scope, Ellen described that, and also the possible consequences, but also in the concept of what is regulated. The FDIS is just the FTIS essentially, we decide if it impacts or if it impacts our national security. Of course, there is also, we have to look into who is doing that, why they're doing it, but essentially you're controlling something that happens in something that has a much closer or much more obvious relation to your territory. But we go to foreign subsidies. So first of all, we're looking at transactions taking place abroad, which with immediate, or we claim they have immediate relevance to the EU space. Second, this is actually third on my list, we're looking into how business activity is organized. So we are actually looking into an entire network of companies, interconnected companies. We're essentially lifting the corporate veil some way. And the other thing which might be necessary for the objectives of the European Union, but is also very intrusive, is that we are looking into the impact of third countries' governmental actions. So a third country might be really trying to help its own companies acquire important assets in a member state, but at the same time, a third country might try to be achieving other objectives at home, safeguarding jobs. So this really gets further there. I'm not taking a position as to how feasible it is, but of course, its consequences, you cannot just, there are different cases, and this requires hard reflection, yes. This brings me to, this is not the end, to some tentative conclusions as to why. First of all, the white paper, which are supposed to be feeding discussion, the white paper must be seen within the modus operandi of the EU. What I would like to hear more from both Eleni and Chris, especially, is to what extent, how much of the white paper is really what the Commission is after. Whether the Commission, even in my less political main field, the Commission is often proposing something more ambitious than what it actually expects or intends to have as a way of actually getting its main target. So how much of the white paper would is really going to make it to, so I'd like to hear more as to how the legislative or the governance process is working in this area. In any case, the white paper signifies an approach of more direct control by the European Commission. If the regulation is about setting a common EU standard or coordinating national approaches, the subsidies paper or the subsidies instrument essentially creates an EU or a federal organ controlling that. So this, again, much more of an American approach in a way. Each state in the US is soliciting actively foreign investment. They have very different interests as to how much they will welcome foreign investment under what terms. The US government is supposed to control that. Of course, we can then talk about regulatory capture and other things, but supposedly it's a national approach there. Definitely, so as I said, there is definitely more potent consequences. Not clear, more potent consequences for the affected businesses. It's less clear to me whether this is going to be reducing the cost or increasing the cost for businesses. On the one hand, by consolidating into a single EU jurisdiction, and also by having much more of a preemptive control. Theory, you will be able, a business wanting to invest in Europe can know in advance that they are possibly violating rules, so they can plan, as opposed to actually negotiating a transaction and then having a denial or screening or denial of approval at the very last stage, which we see also in fields like competition law, for example. anything with mergers and acquisitions, where essentially, as the process has gone far ahead, I mean, of course, businesses have to take into account like serious or even legal advice on that, but you're still not sure if it's going to be approved or not until the very last moment. So at least in theory, this approach will be able to reduce the cost in the long term. But that's in the long term, because in the short term, it's going to take time to build legal certainty. And this is another point, how easy it is to actually think of what will be covered and what not by these rules. Eleni showed us what's going to be triggered, how the process is triggered, and it's quite wide. But what can actually fall under that and what not fall under that? And the other thing is that the US doctrine speaks of long-arm jurisdiction. The idea is that anything that doesn't fall on anything that does not violate, my state has the civil jurisdiction over any case that does not violate the US due process clause in the Constitution, which is something like our fair trial, Article 6 of the European Convention on Human Rights. Anything that is not violating the fair trial falls under my jurisdiction. This is the long-arm jurisdiction. And here we're kind of getting into a sort of long-arm jurisdiction. Say that unilateralism, extraterritoriality tends to be associated more with standards than with rules. Here we have rules, but the rules are very broad, long-arm, and this brings an area for standards. And this brings me to the last point, ordre public. Now, there is this confusion in Greek because you have the original English term was public policy, but public policy also means δικαιοπολιτική, or law and policy, not just sort of in the same way that δημόσια τάξη means both ordre public, talk about that, and Υπουργείο Δικαιοσύνης και Δημοσίας Τάξεως, but policing. But public policy was something really broad, and this idea of the ordre public exception. So in the end, we tend to use ordre public even in English with italics, hopefully for. And then ordre public is an escape. I will recognize, I will enforce your judgment, but certain provisions may not be. I will enforce a civil liability judgment from the US, but the punitive damages of like 3 million for like a claim of $10,000 will not be. Goes contrary to our public policy that compensation is supposed to be compensatory, not punitive. So we have, or I will enforce Saudi family law, but not to the extent that it violates fundamental ideas about equality of the sexes, for example. So in private international doctrine, ordre public is an escape device. It's supposed to facilitate the application of foreign law, but set a limit as to certain things that really go contrary to fundamental legal notions and principles of our law. And there's a long discussion as to what falls under public policy and what not. And this has been changing all over time, all across the ages. It used to be that a 24-year-old person going to the neighboring state to get married without his father's permission was violating ordre public, and his marriage was like invalid. 24-year-old, mind you. And there is another discussion now within the European private international instruments, both on jurisdiction and on applicable law, as to whether we are going to create a European ordre public which is going to substitute or condense the national ordre public. So here, the interesting thing is whether the idea is that we are going, is ordre public or going to be used to condense national exceptions, or is going to be added to the national exceptions? And this, of course, is of crucial importance to us here, because as pointed, what is national security for Cyprus and or Greece is not necessarily national security for Germany. And if Germany thinks that European security is much better served by keeping Turkey close to the Union, for example, then if you apply this European security, there's a valid argument for that from Germany's way, to not to just supplement or complement, but to replace a national notion, national security, then this creates issues. So are you going to add, how are you going to define ordre public? This is going to give business to the European to the Court of Justice, probably in the long term. Are you going to add or are you going to subtract? As to how to manage ordre public, but I will stop here. Effet atténué. In choice of law doctrine, there is this idea that the same legal situation might run contrary to my public policy, my ordre public, in some cases, not in other cases. So I might allow a polygamous marriage to have effects, either just passing from my country, but not if they're living here for so many years that it violates my country's fundamental ideas. This special goes in. So this effet atténué is there. So there are tools, and it's going to be a very interesting discussion. On the other hand, this is not just like litigating a contract or a marriage. These are cases that have to be designed and settled in advance. So ideally, this is not something that you want to take all the way to the Court of Justice. The idea is you want to know what, as a business or as a lawyer planning for a business, you want to know what is permitted or not in advance, not to litigate if possible.